Aloha, everyone. Mahalo for joining our Legacy 102 Lessons Learned in Trust and Estate Administration. My name is Janelle Lyman, and I'm the Senior Director of Gift Planning and Advisor Relations at Hawaii Community Foundation. Today's webinar is a part of our Legacy series we present annually to provide helpful information about wills, trusts, and estate giving to our donors, advisors, partners, and supporters. Some of you may recall that in 2023, our first in the webinar series, Legacy 101, was held on April 12th with guest speaker Kanani Makai Moku of Sterling and Tucker, who presented information about the basics of an estate plan, why it's important to have one, how it works, and what can happen if you don't have one. If you didn't attend this webinar or would like to listen to it again, the presentation is available on our Leave a Legacy page on HCF's website. We then scheduled our Legacy 102 for September 14th. However, following the Maui wildfires on August 8th, we postponed the presentation for the community and HCF to rapidly respond and assist to the people and places affected. Today, we're excited to continue our learning series as we all have something to learn and we're here to help you. So a few housekeeping notes before we start. We will answer as many questions as we can, saving about 10 minutes at the end of the presentation. So please feel free to use the Q&A box at the bottom of your screen for your questions. On another note, the presentation is being recorded, and we will send you a copy of the recording and slides. So look for the email in a few days. Our speakers today from HCF are Kavena Beaupre and myself. Kavena joined HCF in 2014 as Associate General Counsel and was promoted to Senior Vice President and General Counsel in 2022. Prior to HCF, she was an associate in the tax department at Cage Schutte, where she practiced in the areas of tax and finance. I joined HCF in 2017 and will share my lessons learned in estate and trust administration from my pre-HCF years as an attorney in family law and trust and estates, and as former vice president and team leader with First Hawaiian Bank's personal trust department. At HCF, I lead the professional advisor, gift planning, and legacy programs, working with advisors and clients to support their giving in the community. Today, we're also thrilled to have Kevin Shinoki with us to share his trust and estate administration stories and expertise. A little bit about Kevin. In 2019, he founded Legacy Works, which is a private fiduciary firm specializing in trust administration and estate litigation. Kevin's undergraduate degree is from the University of Washington, so go Dogs, and he received his law degree from UH Manoa's William S. Richardson School of Law. Kevin has been specializing in trust and estate administration for over 8 years. Our agenda today begins where we left off last year. So for today, we are assuming that you have an estate plan in place, and the next step is what happens when you die. Or in another scenario, you are named as a successor trustee for a decedent's estate. And so here we'll first begin with a brief overview of the role and responsibility of a trustee. And next we'll get into the meat of our presentation with common pitfalls and lessons learned in trust administration. So as mentioned earlier, we will leave a few minutes at the end for questions. So please use the question and answer box at the bottom of your screen. So we're going to start first with the role and responsibility of a trustee. The first thing really to keep in mind when you're naming a trustee or are nominated to serve as a successor trustee is that their role should not be taken lightly. So trustees are personally accountable for their actions. They also have a legal obligation to act responsibly and prudently to carry out the purpose and intent of the trust. So for some, being named a trustee may initially be regarded as quite a compliment, but it can be a daunting endeavor, as you will hear throughout the presentation. So think of it more as a job, a responsibility, and an honor to be named a trustee. So as trustee, you have a fiduciary duty to act in the best interest of your beneficiaries. And what this means is you must put their interest in front of your own. following rules and established standards of conduct like honesty, integrity, impartiality, professionalism, and competence. So sometimes it may be difficult for a beneficiary to also be a trustee because they may face conflicts between their duties as a trustee, which involves acting in the best interest of all beneficiaries, and their own personal interests as a beneficiary seeking to maximize maybe their own benefits from the trust. There's also a risk that the trustee beneficiary may engage in self-dealing, and in this case, make decisions that benefit themselves as a beneficiary, maybe at the expense of other beneficiaries. So for example, this may include spending trust assets to improve real property, where the trustee is the sole beneficiary of the property, or other beneficiaries and other beneficiaries of the trust receive only cash and other assets. To successfully administer the provisions of most trust agreements and its assets, understanding the legal and financial aspects of trust and applicable law is crucial. So this includes knowledge of trust documents, tax implications, investment strategies, and accounting principles. The next slide really gives you a brief glimpse of the steps involved in trust administration upon the death of a grantor. So a grantor here is the individual who creates the trust. The first step is really to get a full picture of the assets and the wishes of the grantor. So you must carefully review all available documents to get an understanding of the type of assets and the amount of the trust. One of the first documents to review, of course, is the trust document to understand who the beneficiaries are and what your trustee's powers what you can or cannot do. The next document I would recommend reviewing is the grantor's past tax returns, which really gives you a good snapshot some of the grantor's assets, especially income producing assets. So now that you're aware of all the trust assets, or at least have an understanding of it, the trustee is responsible for then securing and valuing these assets. And whether this be completing the account paperwork to be sure that the investment and bank accounts are properly titled, securing the real property that's held in trust, or inventorying the personal property in the grantor's home. Taking an initial inventory of all of these assets and valuing them as of the grantor's date of death is essential. So all trusts include a variety of assets: bank accounts, retirement accounts, real property, and even vehicles. And it's the trustee's job to make sure that all of these assets are accounted for and secured. The transfer or collection of assets usually requires an original certified copy of the grantor's death certificate. And so for here, the tip is to be sure you request enough copies. And I recommend anywhere between 5 and 10 copies. So they're usually ordered from the funeral home or the county in which the grantor resides. And so it can sometimes take actually up to 6 weeks for to receive the death certificate. And so it's important to request this as soon as possible. Next, under Hawaii law, the trustee has a duty within 30 days of the trustee's acceptance of the trust to inform in writing any person or persons entitled to benefits from the trust. So here, one thing to note: when a person, fiduciary, bank, or trust company is named as trustee in your estate planning documents, it's just a nomination. And so what this means is that the individual or corporate entity must accept the responsibility to serve as trustee. They can also decline the nomination as well. But once the trustee has accepted their role and responsibility, this here triggers the trustee's duties with regard to the assets and informing beneficiaries of their interests. And some of this duty may also include providing a copy of the trust to that beneficiary, describing the beneficiary's interests, providing information about the trust assets, and any particulars relating to the trust administration. Besides notifying the beneficiaries, the trustee is also responsible for notifying the grantor's creditors. And this can be done through a filing of a notice to creditors in a newspaper of general circulation where the grantor has lived. If a notice to creditors is published, then what this means is that the creditor has 4 months after the date of publication to make a claim. So if there's no claim is made during this 4-month period from the creditor, then they will be barred from collecting on the debt. So every state has specific requirements on the timelines to notify the beneficiaries and creditors. And it's important to do your research, making sure you follow these federal and state law. In Hawaii, if a trustee does not provide a notice to creditors by publication, the creditors will have 18 months after the decedent's death to collect any debt from their estate. So here, this is where sometimes you have to be careful because personal responsibility and liability. If a trustee distributes asset before this 18-month period expires, they could be personally liable for the debt. So keep that in mind. And next, paying any debts, taxes, and final expenses. After the grantor's death, the trust becomes irrevocable. So what this means is it has to get its own separate tax paying entity. And the trustee must get a tax ID number for the trust. And you can do this through the IRS website. A trustee executor is usually responsible for filing a final tax return to the grantor for the grantor. And the IRS is usually the grantor's most important creditor to notify and settle any debts or payments that they may have. Of course, the decedent may also have other outstanding debts like medical, credit cards, loans, and the trustee must pay these from the trust assets. Once the trustee has completed steps 1 through 4, the last step is to distribute the trust assets in accordance with the terms of the trust document. So some trusts may distribute it outright to the beneficiaries after the administration is complete, while others stay in trust for many years for the benefit of the named beneficiaries. And as trustee, following the grantor's wishes is a high priority. So as grantor, you want to make sure that you select a trustee who will have the knowledge and skill to understand and execute these steps, and that you can rest easy knowing that your wishes will be honored. We do have a few advisors listening to our webinar today, so never be afraid to reach out to the grantor's estate planning attorney, financial advisor, or accountant if you're stuck on any of the steps previously mentioned or have any questions. So now that you know a little bit about the basics of a trustee's role and responsibility in trust administration, we are really getting to the fun stuff. So lessons learned and common pitfalls in trust administration. Here, I'll turn it over to Kevin to tell you about lesson learned number 1, selecting the right trustee.
Okay, thanks, Janelle, and good afternoon. Selecting the right trustee is a really critical part of your plan, but many people don't think much about it when your estate planning attorney asks you who you want to act as your trustee. Your options are naming a family member, like a adult child, a bank or other corporate trust company, or a professional fiduciary or attorney. The usual answers that I hear are just put the banks or put my son or daughter since they're better with money. I think once you know more about the actual job of being a trustee, you'll make a more informed decision about who you want to select for your situation. So let me give you a starting framework to make your decision about who should be your trustee. So there's 6 main considerations that we've come across that most people are thinking about. Cost, the time it takes and the time it takes to administer everything, decision-making ability, record keeping, and the liability aspect. First, we had many questions about costs and fees sent in for this webinar, so I'll tackle that first. All professional fiduciaries or trust departments have a published fee schedule. Hawaii Revised Statute Section 607-18 gives the statutory fee schedule for trustees. Section B covers attorneys and companies who are in the business of trust administration, like Legacy Works, First Hawaiian Bank, Bank of Hawaii, and Central Pacific Bank. Section C covers anyone acting as a trustee who does not do trust administration as part of their normal business. So the way most of the fee structures are set up are like this. The basic structure is it has four parts. There's an inception or a transfer fee to onboard a new client that usually runs about 1%. An annual fee that runs between 1 to 1.6% from the schedules I've seen. And you got to think, well, why is it an annual fee? Does it take that long? So I just want to let you know the average time for administering a trust can be 18 months and up. The more complex it is, the longer it can take. So this is not a quick process. There's an income fee, which is usually 5%, and then a termination or transfer fee of 1% at the end of that trustee's job. So let me go over those real quick so you understand a little more about what each one means. The inception or transfer fee is really the fee for onboarding a new client. There's a lot of work involved in taking over a trust, from transferring bank accounts, dealing with properties, meeting financial advisors, and figuring out the finances, bills that need to be paid right away. It's a whole list. So there's a lot of work that goes into it. The annual administration fee covers the ongoing work that the trustee does over the course of the year. Whether it be taxes, beneficiary distributions, communicating with the beneficiaries, the trust accountings, that's all wrapped up in this ongoing fee because it's work. This fee is normally discounted the larger the estate is. So if you look at that HRS section, there's tiers to it, and you'll see what I mean. The income fee is based on the income of the trust, which typically refers to dividends from investment portfolios and also rental property income. So it helps cover ongoing communication and work that we do with the financial advisors and property managers that we have managing the residential and commercial properties that our clients have. Lastly, the termination fee is what covers the final distributions, communications with beneficiaries, final accountings, and sometimes transferring the role of trustee to a new person or company, like the adult children of the settler who may want to take over once all the hard work is done. And yeah, that happens. So overall, the fees tend to be based on the value of assets in the trust. And so it's in the best interest of the trustee to grow and be conservative and preserve the assets of the trust because it does translate to a higher fee. So that's just a little question about covering some of the fees. So I want to go over the different options. The first one I'll cover is family. This is probably the most common one, so I'll spend a little more time on this option. It's natural to want your family to handle the responsibility, but here's some things that you may want to think about first. Your family dynamics. Are the kids getting along? If you have more than one kid, is this going to save money? Well, maybe. If you expect your kid to do all this for free, then just know if they're not an only child, there might be some resentment down the road about that. The work of the trustee takes time. And if the trustee already has a full-time job, it can be very challenging. That's why we have whole companies and departments within the banks to do this. It does take work. Communication is critical. Making sure that the trustee is communicating with beneficiaries, and it has to happen whether or not they're getting along. They need to be able to communicate and provide updates about the trust. So when I talk to trustees who find out how much work it is to administer the trust, a lot of times they resent having to do the work with not being paid or receiving any appreciation from their other beneficiaries, which is their brothers or sisters. And like I said earlier, when your son or daughter is working 60 hours a week and one of the siblings keeps calling them to see when they get the distribution, relationships can get strained. And if it gets real bad, well, it'll end up in court, like I think everybody's seen. So as far as the work itself goes, how much time are we talking about? It's like a part-time job. You're filling out forms, you're mailing or dropping off forms to government offices, investment advisors. You're on the phone with Social Security, property managers, securing the house, taking care of, your parents' house, doing an inventory, the list goes on. And so if the person already has a full-time, daytime job, it's pretty tough to get all this done, during the normal course of a day, when you're sitting at your desk doing your normal job. Uh, so, something to consider. The ability to make difficult decisions is just a nice way of saying, can you say no? We've had beneficiaries with substance abuse problems that try to emotionally blackmail their mom to get money. You know, uh, we've actually heard them say, give me money or I'm just going to kill myself. It's awful. Um, we had a beneficiary tell us that he scheduled a trip to Vegas and he needed us to give him $40,000 for spending money. After we laughed and we said no, he laughed and said, "Oh, I was just testing you." So, things like that happen. You got to be able to do the right thing because it's not your money, it's your parents' money. Uh, the record keeping, this one is one of the areas that causes the most problems, really, for family trustees, because you're keeping receipts, putting together financial statements, arranging for taxes to be done. It's like Janelle said, some business knowledge and understanding really helps here. Um, it's very similar to running a business. You need to keep track of revenue, expenses, investments, vendors, distributions, property managers, and the list goes on, right? When these responsibilities are not handled properly, whether or not you had a good reason to do so, it can lead to a costly battle in court. Communication, that's one of the requirements of being a trustee. Like I said earlier, whether or not you're getting along with your siblings, if you're the trustee, it's important to make sure that they're still getting updates about the finances of the trust and anything else that you want to keep them up on. Um, Lastly, when I'm asked, if a client should name their son or daughter or a third party as a trustee, I ask them, have your children ever worked together on something together as adults? Um, because it's different when everybody gets along as kids and maybe, cordially everybody's fine as adults, but have they worked on something together? Because that's what this would be. Remember, most fees for trustees are in the range of what you pay your financial advisor, or pretty close. If it will keep harmony in the family, everything's done transparently and, impartially, and it relieves your children of any of the headache, you may want to consider using a professional company to run your family's trust. I have one example to sum it up. We took over a very complex trust with a lot of commercial and residential property uh, a few years ago. Unfortunately, the last surviving sibling had been trustee for 12 years. And, he was doing his best to take care of the family properties and collect the income. But because it wasn't very business minded, he would pay repairs and construction repairs on the houses in cash and write out checks to himself made out to cash. He would commingle funds with his personal funds and credit cards with the trust. And when a couple of his siblings' children decided to sue him, we did a 12-year forensic accounting. And unfortunately for him, he got charged back for all of the not clearly documented expenses and all the attorney's fees, and the total penalty to him was just over $1 million. So it was a very, very costly endeavor for him. And I felt bad for him because he was a nice guy and he meant to do well. He just did not understand that once he took the role of the trustee, a different set of rules applied. So anyway, let me go to option two. Professional trustees or attorneys like us, Legacy Works. There's some other great companies out there. We're going to do the job impartially. Our fees may be higher than having your family do it, but somebody else is doing the work. We have a professional network, and we're professionals, and we care about doing a good job. Hawaii's small, our reputation is very important, and so we're going to do a good job. And lastly, The banks here, First Hawaiian, Bank of Hawaii, and CPB have a great staff and a lot of experience behind them. You know, if you meet their requirements, and I highly encourage you to talk to their trust departments to see if they will accept you as a client, they'll do a great job. Um, and yeah, so with that, I want to turn this back over to Kavena.
Thanks so much, Kevin. Um, Great stories. Thanks for sharing that. I think your points about, who can serve as trustee are very well taken. And so the next 4 lessons learned that I'm going to talk about are really more kind of common sense, I think, items, but as you'll hear, they are also common pitfalls with real consequences that have occurred. So lesson learned number 2, that is, where are your estate planning documents? So, you've met with your attorney, you've signed your estate planning documents, they send you off with a binder of your documents or, an envelope, and then you go home. What do you do with your documents now? Where do you put them? So that's what this is kind of covering is, the best, I think, advice we can give is to put them in a safe place. The number one probably option would be a safe deposit box. But there's a few things you have to remember or should, take note of if that's what you're going to do. One is to just make sure that the name of the box is in the name of the trust and not in your individual name, because that will allow your trustee to access the box in case of your incapacity or death. Also, make sure you know what the procedures and requirements are for accessing the box. If you're not able to do it, right, how can somebody else get to the safe deposit box? And then I think the number one thing would be just to make sure that you leave instructions for where the keys are for the box. I think, people take for granted that maybe the trustee will be able to find where that key is, or they, should read your mind and know where you left it. But if you leave instructions for the successor trustee or whoever's, to take over where the keys are, that way they can access the safe deposit box where you're keeping these documents safe. Another option would be, and I think this is probably the most practical and probably most used by everyone, is you keep it in a safe place in your home. Whether that's in like a file cabinet or on your desk somewhere on a shelf. I think the key here is just to make sure that somebody knows where those documents are. Maybe label it well so that somebody, can easily identify that it's your trust documents. And then I think the last option is leaving it or making sure your attorney has a copy of your estate planning documents. But I think the caution here is that you shouldn't depend on your attorney. You should be the one responsible for making sure you have your estate planning documents. I think some attorneys do, hold copies for you, but you can't rely on them, especially if you're using a solo practitioner. It may be a challenge to get to those documents should that person pass or move away or, retire. And then we generally don't recommend that you give copies of your trust documents to family members or friends just in case. And the main reason is you may end up you likely will amend your trust several times. And so this alleviates, the chance that there may be multiple versions out there. And people think the one they have is the current version when it's really not. And so I guess before we move on to, I was going to cover the don'ts, Kevin has a story to share about safe deposit box.
Oh, well, it's just a short story, but I did work with a client's estate that was way out in Kahuku, and nobody could find her safety deposit box keys. And we went out there, had to schedule the driller. Out of 5 boxes, we drilled all 4, emptied it out, inventoried everything, and the 5th box had the keys to the other 4. So yeah, that one key would have been really good to have found before we had to do that.
So for me, as for the don'ts, I do have a story and lesson learned again that involves a safe deposit box. And then, so just keep in mind that as Kavena said, the safe deposit box access is only during bank hours. So if your decedent dies on a Sunday or at night, of course, the box is not available. I had a client that died early Saturday morning when I received a call from his wife, from the wife, and she wanted to go to the safe deposit box. Really, she said, I really want to get my more important documents. On Saturday, some of the banks closed before 12 o'clock. So I took her to the bank to get her documents. And when we returned home, I swear, kid you not, she wrapped the documents in tin foil and stuck it in her freezer. So if I did not see this for my own eyes, I wouldn't have believed it. I wouldn't have believed it or even searched for those documents in her freezer when she passed away. So that's just kind of a, crazy note. I've also found really important documents, even cash in old magazines, literally under beds or mattresses. Another story that I had, one client I worked with him 5 years prior to his death. He was blind and he received his care in his apartment. So there was a lot of different people coming into his home. So he, was wary and didn't trust too many people, but he kept telling me, oh, when I die, don't forget to go to my safe deposit box. He told me where his key was, and I said, okay, I will. And when he did die and I went to his safe deposit box, he actually left me a map to his apartment that then led me to a false drawer in his kitchen at the bottom of his cabinets and drawers, and it held important documents regarding his military separation, as well as information with regards to his pension. So he also provided another map, which then took me to a diamond ring that he hid in a medicine cabinet in the bathroom. So he basically cut out a corner of the cabinet and he created a space for this ring. All these are just, very eccentric, unique examples, but it actually happened. And moral of the story is basically to tell someone or leave instructions for your trustee where to locate your safe deposit box keys or your documents and valuables.
Thanks, Janelle. That's really taking safe to the next level for sure. Okay, lesson learned number 3, failing to fund your trust. Creating your trust is just the first part of the estate planning process. Once you have your trust in place, the next step is really funding it. You have to put assets into the trust. And so the way, it's been explained to me is you think about your trust like an empty box or a treasure chest. So it can only protect the assets that you put into the trust. Some attorneys will do the funding work for you, and others actually just leave it up to you as a client to fund it. So when you're working with your estate planning attorney, just make sure that you understand, what services they're providing for you and whether or not that includes the actual funding of the trust, or if you need to seek out another attorney to help you with that. And I think this is a good kind of lesson learned, because I think people either don't understand that that's like the next step of, after you create your trust, or they actually don't take time to follow through with it. So a helpful tool is to just make a list of all your assets and include a column which states how the asset is owned and whether the asset list has a beneficiary. And make sure to include this list with your other estate planning documents. So on this slide, we've included a few of the assets that are commonly used to fund the trust. The first being a checking account, and just the tip here is to just make sure that the account is titled in the name of the trust. So it would be, Jane Doe as trustee of the Jane Doe Revocable Trust, and that it's not in your individual name. For real property, if you have property, most times it'll be your home that's intended to be a trust asset. You have to get the property titled in the name of the trust. And here's where your attorney comes in. They can assist with, drafting the deed and getting it recorded. But you should make sure that this is part of the service that they're providing. And then,
oh,
go ahead, Janelle.
No, I do have a lesson learned with regards to the real property. And so this has come up kind of often. If you're don't title it into the name of the trust, sometimes people hold it real property titled as tenants by the entirety. So this is how it's held between husband and wife. You just need to make sure that after the first spouse to die, the property is retitled into the surviving spouse's trust. So I've had situations where the real property held jointly between husband and wife. Husband dies, but there was no retitling of the property. And when the wife dies, that property is considered to be held in her individual name and then must be probated to transfer to the beneficiaries. So lesson learned there.
Yeah, that's a very important point. Thanks for bringing that up. And then another asset or assets that can be put into your trust are just personal property. And this is usually done via an assignment or some kind of similar document that you would sign at the time that you sign your trust to be part of your trust documents. Your trust can also be funded with other assets, one being business interests. And I know Kevin had an interesting story that he wanted to share about a client with business interests.
Oh, yeah. Thanks, Kavena. So yeah, just a note, for a lot of folks who have business interests or, professional, doctor, dentist, or a construction company, I ran into two in the last month where the owner did have estate planning documents. He transferred properties in, but he didn't transfer his business interests into the trust. And unfortunately, we have to go through probate to deal with those. So yeah, keep it in mind, business interests, so it's part of your assets. Yeah.
Next is, I guess, retirement accounts. So retirement accounts to keep in mind on that, and best lesson learned is that they're the highest taxed assets in any estate when left to individual heirs. So they're actually double taxed. And here it's because it's counted for estate tax purposes, as well as your heirs will pay income tax on the distribution. So it really means much less money is being paid to your heir. So to keep this in mind when you're thinking about who to name as a beneficiary of the retirement account. If you are charitably inclined, the best asset to leave to a charity is a retirement asset, because naming a charity as a beneficiary, the charity receives a distribution directly, and then there's no income taxes owed. And also with regard to the decedent's estate, the estate will receive a charitable deduction for the amount given to the charity. Naming a trust can be tricky. There's this whole slew of a body of law on that. Non-individual beneficiaries such as estate or trust, they're subject to a 5-year rule, which requires that the distribution of the entire amount is needs to be distributed within the 5th year following the decedent's death. And so this means it accelerates kind of paying the taxes. And keep this also in mind that the trust receiving the funds, if your trust is a beneficiary, it's taxed at a high income tax rate. So I think that rate is about 37%. Versus if it goes out to the beneficiary will pay their individual income tax rate, which may be lower. And then if it's a charity, the rate is 0. So that's like even better.
Good point. Okay, lesson learned number 4, failing to regularly review and update your trust. So generally, estate planning attorneys recommend that you review your estate planning documents every 3 to 5 years, or if something changes. And I think there's 3 main changes to take note of. Here would be, change in relationships, family dynamics. If you have a birth of a child or a grandchild, or there's a death in the family, or marriage or divorce are also important, changes in life. Most trusts are drafted with some kind of contingency language, but some actually are not. So you'll want to just ensure that you make sure so that you can ensure that the outcome is as you envisioned it, as you planned. Another change would be change in assets. If you purchase, a home or you sell a home, this would necessitate a review of the trust. And this would allow you to also include new assets or modify, how assets are to be distributed. The last would be a change in laws. So which may have very real tax implications, especially since the current estate planning is being done under 2 different tax exemptions, with the federal and state being different under Hawaii. So that could be a reason that you may need to relook at your estate planning documents. And then different laws may apply if you move out of state. And I think just here it's just, trust in general, they're complex. Your situation may change after a few years of creating your trust. So it's just important, I think, to keep that top of mind, that it should be reviewed, every so many years. And if you do have a change in circumstance, that would be another important reason why you should have your plans reviewed.
Yep. Kavena, so I just wanted to also mention, so recently, especially with the federal exemption for estate tax sunsetting in 2025, we've had a lot of people really looking at, high net worth individuals who would be affected. We have them looking at, different ways to pass on as much of their assets as possible, using family limited partnerships, discounting values. So that's going on a lot right now. So just wanted to mention that.
Yeah, thanks for that, Kevin. Okay, and we're at our last lesson learned. Lesson learned number 5, correct beneficiary name. So, beneficiary designations are a simple way that you can leave direct specific assets to an individual. However, you have to, I think, our caution here is do that with care. And what we mean is, if you're naming people, individuals, make sure that you spell the person's name correctly in the trust. If they have a common first or last name, make sure you include a middle name, which would be helpful in identifying them. And also, I think what's helpful is if you include the relationship that you have to that person, whether it's your cousin or a niece or a friend, or even how you know them, and include contact information for them. We had a trust that we were involved with. We were named as the residuary beneficiary, and there were multiple individual beneficiaries that were named. And there were actually a few names, believe it or not, that were spelled incorrectly in the trust document. And so it was hard to locate these people. I think there were one or two beneficiaries that actually had very common names. So when you do a general search, there's, people from all around the world that come up with that same name. And then we didn't have any contact information. The trustee had no contact information, didn't know what the relationship was that these people had to the decedent. So the trustee actually had to hire an air search company, both local and then national, to help locate the beneficiaries. So this is, this is really a cost and expense that could have been avoided had just more information been provided in the trust document, or, attachments that were included with your binder of estate planning documents to help the trustee identify beneficiaries. And then if you name a charity as a beneficiary of your trust, just make sure to include the correct legal name of the charity, not the DBA, and then include their federal ID number. And then if it's a national charity, if the intent is to support the local chapter, just make sure that that is explicitly, included in the trust document as well.
One lesson learned on a charity or an organization that I came across is actually also to make sure that your named beneficiary or organization can accept your bequest. So I had a grantor that left a gift to Punchbowl. So the National Cemetery of the Pacific, it's not a 501c3 charitable organization, and is administered by the United States Department of Veterans Affairs. So when we tried to send them a very large check, they actually didn't know how to allocate it to Punchbowl, and actually how it could get deposited in order to, to get it to the right beneficiary, so to speak. And so it took over a year before the check was cashed, and in which time we had to continue to keep the administration open until I guess the Department of Veterans Affairs could figure out how to get that to the right organization. Okay. Well, I think we've got just about 10-12 minutes left for some questions. So we do have a lot of questions that we have, just wanted to make sure that, that the bottom line of the role of the trustee is a job. And so this shouldn't be taken lightly. And the first questions that we will kind of take a look at right now is some of the questions that came in when people RSVP'd for today's webinar. And the first question is there a simpler way to transfer real property at death without having to establish a revocable living trust? And so I'll pass that over to Kavena.
Yeah, thanks, Janelle. I think one way that we've heard of that you can do this, it's called a transfer on death deed. And it allows the owner of the property to name a beneficiary who will inherit that property when the owner dies. So you sign and you record a deed now, naming the beneficiary, but it actually doesn't take effect until your death. And you can revoke the deed, or you can sell the property at any time. It doesn't prevent you from being able to do that, because the beneficiary actually doesn't have any rights to the property until you pass. So I think that would be, one way that we know of to accomplish that.
Okay, let's see. The next question does a designated beneficiary of a bank account have leverage over a decision of an executor of the trust? And so I will answer that question. And so for this question, it depends on how the bank account is titled. So when funding your trust and your assets, if the bank account is titled in the trust name, then the trustee will have responsibility over that asset. But if you leave the bank account and there's a payable on death, beneficiary designation, which leaves an individual, then the bank will provide that control, and the assets in that bank account will go to that named individual. Okay. The next question is for Kevin. So are there instances where the grantor of a trust can name or assign someone as trustee without that person's knowledge or authorization?
Yeah, and the answer is yes. Anybody can, like the banks experience this every day. There's hundreds and hundreds of people who have named the banks as their future trustee, but and they don't know it. They haven't received a copy of it. We have those too. And it also doesn't mean that the named trustees have to accept, right? They can still decline. So yeah, circling back to what we said in the presentation, it's good to know whether or not your named trustee is planning to accept your estate once you pass on.
And this kind of also goes to a question that was asked in our Q&A, is like, why wouldn't you give a copy of the trust to your trustee, or inventory of your document? The recommendation is mostly to kind of leave it with your trust documents. And this is because, your trustee may not accept, the trustee, you may change it. And so like how Kavena said, there may be, a time where, there's going to be multiple copies out there. So you just want to make sure that the trustee and who you eventually named is going to be the right person, and has the proper documents. So let's see. Here's another question. Oh, maybe to Kevin. The question is, my mom is still alive and has named me as trustee of her trust. If I decide on my death that I can't handle the responsibilities, can the trusteeship be turned over to a professional, and how?
Okay. Yeah, that's actually a really good question. So the first thing that you need to do is look at the trust, because it probably has successor trustees as backups to you. And if you wanted to turn it over to a professional, that's great, but the next trustee in line may not. So you'd probably need whoever's named next to decline the job. And then the beneficiaries, usually there's always a mechanism to appoint a new trustee. Like majority of the beneficiaries have to agree to, appoint XYZ company as the trustee. So that would all be found in the trust.
There's another question here. I think, Kevin, you can take this one.
Okay.
It says, why do you say that naming family members may save money? I know people who have named family members in order to save money. What would it only cost something if the family member makes mistakes?
No, the family member can do all the work for free if they want to. And I've heard a handful of good examples where everybody gets along. Like this one, the son was he's a controller and an accountant. He did all the administration for his two sisters, and it went off without a hitch. That's probably one of the best cases I've ever heard of. And he didn't expect to be paid. But I wouldn't say that's the norm.
Yep.
Yeah.
And I would also say
But
that
they are entitled, right? They are
Yes.
entitled
They
to
are
a
entitled
fee.
to
It's
be
whether
they
or
paid.
are
not they take
entitled.
it. Yeah.
Yeah. So if you're assuming that they're not going to take a fee, that's just really an assumption, because they are entitled, like how Kavena said, they are entitled to a fee. And it's a big job, definitely.
Yeah, I've seen another one where, okay, so the named trustee was here in Hawaii, other siblings were on the mainland, and for the job of doing the trustee, this one particular individual got the family house, right? And the other two siblings got, money, not quite as much as the value of the house, but they got money, and everybody understood and accepted that that was fair. Person had also taken care of mom and dad, during their later years. So everybody was cool with that.
Yeah.
Mm.
Here's a question for you, Kavena. If the trustee resides outside the state of Hawaii and the grantor resides in the state of Hawaii, what laws govern the trust assets, such as the situs of the property?
So the laws that would govern would be where the trust was created and where the assets are held. So it would be the laws of Hawaii.
Yep. And usually the trust document will say what the situs is.
Yeah, they say what governing,
Yeah.
what law governs.
What law
Correct.
governs. So sometimes, sometimes people from Washington State, but live in Hawaii. So so everything kind of goes back to the trust document as well.
Mhm.
Okay.
Mm.
Few more minutes.
Sorry, I'm looking at the chat too, Janelle.
Yeah. Okay. The question came up, which is interesting. So is there an entity who oversees whether a trustee is fulfilling their fiduciary duty, or is this typically based on an honor system? There's not really a overseeing body, like for charitable trust there is, which is the Attorney General's
In
office.
general. Yeah.
But for personal trust, no. And and Kevin's a part of a lot of litigation, and so that's pretty much how you resolve any issues, conflicts. We've seen that individuals and beneficiaries have to just kind of lawyer up and resolve their differences in court. And that's where the expense comes in, right? That's where you're just it's hard in those situations. I mean, Kevin,
Yeah, I think that's really to Kevin's point, right, about who serves as trustee. I think that's probably one of the most important decisions to make when you're creating your trust, because that hopefully will alleviate the chance of having litigation or having to go to court, is if you put the proper person or persons or corporations, right, companies in place up front. So, yeah.
Yeah, I agree. Yeah.
Let's see. What questions should family members be asking to understand if a chosen trustee is meeting the trustee and fiduciary responsibilities? Oh, that's a hard one.
Well, I mean, there's some basic, a list of basic duties. You can search the internet. I'm sure, one of us can send someone, a list of the trustee duties, but the communication, the regular reporting, um, you know, backing that up with, if you have financial statements, backing it up with bank statements if they have, questions, list of receipts, where's the money being spent to, repair mom's house before we sell it, whatever it is. But yeah, if there's communication, that's a good sign. If there's regular reports and financials, that's a good sign. And for someone who's not a professional trustee, that's doing pretty good, you know.
Here we only have a few more questions, but this is on the business side. The question is, won't a business interest be included in the pour over will, and what assets aren't included in the pour over will? So pour over will means that you still have to get it probated, right? The will is not affected until you present it to court. So in that sense, you will have to, that's the additional expense, right?
Yeah.
So
And the number
yeah.
that you're looking for is $100,000, right? Try to keep the
Yeah.
estate under $100,000. And, I gotta say, most business interests are worth more than $100,000. So yeah, you definitely want to think about how you want to handle that before, you end up in your family ends up in probate and they weren't planning to.
Yes.
Yeah.
Well, we're at 1 o'clock and we haven't really answered some of the all of the questions that we have, but so we will try to answer them in our post event email if we can. And we will provide a recording of today as well as the presentation slides to you. So and if you have any questions, again, you can always reach out to us with those questions. But want to thank Kevin and Kavena today for wonderful lessons learned.
Oh, thank you
And
very much for the
yeah,
opportunity
Thank
to
you.
share. Yeah,
Yeah.
thank you.
thank you all.
Thanks everyone for joining.
Yep. Happy Pi Day.
Yep. Okay. Okay,
Bye.
take care. Bye-bye.
Okay, so Harmony, everybody okay? I see good to go.
Yeah.
I think we did okay. We did great.
Great job, you
Mhm.
guys.
Thank you. That was fun.
I was having technical difficulties in the beginning. I couldn't get my document that I was gonna have my outline on from into my screen where I could look at the camera. So I don't know if it looked obvious. I was like looking to the side, like, oh my God.
No,
I didn't
notice.
notice
Yeah,
that.
I didn't
I
know.
didn't notice.
Oh,
But
my
that's always my
goodness.
problem too, right? Sometimes your like document like disappears and
Yes,
and,
yeah,
and especially like I have like where you look on the screen versus
yeah.
where everything else
You
is.
can
It's
tell when you're looking, yeah, a different direction.
yeah.
Oh
Yeah.
my gosh.
Yeah.
No, I think everything went good. Kevin, thank
Yes.
you.
Oh, no,
Yeah,
thank
thank you
guys.
so
Yeah.
much, Kevin.
Was that all right?
Looks like a lot of people, I think as always, a lot of people enjoy the personal stories that
Yeah.
brings like the point to life, right? So I'm glad we were able to incorporate a lot of those.
And
Yeah.
the more interesting, the better, right? Because
Yes, exactly. And so that's really our good hope that we have. So there are questions that we didn't get to because they seem to be kind of
Yeah.
a lot. So thanks, Kavena, for jumping in because I'm like, oh my gosh, no,
So
Yeah, I know.
sorry about
in
that.
There's
the
a lot.
chat and then the Q&A, and I'm like, where do I go?
Yeah. No, but I think that was perfect timing. I was watching the clock. I think we started at like 1:48-ish for questions. So that was a good amount of time. And yeah, we'll just take the ones that we didn't get to. We might as well just put a whole list together, right? And answer all
Yeah.
of the ones that came through.
Yeah, so if Harmony, if you can do that, that'd be great. And then we'll just put that out along with our post-event recording as well as our slides and yeah, Terry, if we can put something together on that. You know, I see that we had like 140. So again, we said like, oh yeah, that like 230, like that was a lot.
Mhm.
And so, but even over 100, 125,
Yeah.
that was still really
Good.
one of our highest. Um,
Mhm.
you know, and if you look at the comments, really, some of them are like, oh, amazing, thank you. So good.
Yeah. It was very practical. That's why I think,
Yeah,
which is
yeah.
always, yeah, helpful.
Kind of what we want to be able to do is
Yeah.
give that advice. So yeah, that's great.
Mhm.
Kevin, you have any?
No,
Any
I just
last final
appreciate it.
words?
So, do you guys need help on any of these? Are you guys gonna respond to the rest of the questions that we didn't get to?
Oh, no, we
I
will
think we need your
absolutely.
help. Yeah.
We will absolutely need your help. So I think for the next steps is Harmony will put the questions together and
Oh,
then
okay.
we can just either put it in a document where we could answer and then get it into a final form and then we will attach it with our post-event like
Email.
thank you, here's a recording, here's a slides, and here's the additional questions that we weren't able to answer or that came in.
And I know you're leaving, what, tomorrow, Kevin, on your
Oh,
vacation?
yeah.
Oh, yeah. Well, I'm gonna have my laptop with me, but yeah, let me know.
Okay, we'll try to answer as much as we can. Maybe we'll just highlight the ones that we need you to answer, Kevin.
Yeah.
Yeah.
Wait,
Yeah.
where are you going again? You guys are going Tahoe.
Whistler.
No, we're going to
Whistler, yeah.
Whistler. We're gonna fly into Vancouver, spend one day,
UW.
checking
Oh.
out. No, not UW. We did
You're not
that
gonna.
a few years back, and then we're gonna take the shuttle up to Whistler and go sliding around on some snow. So that'll be fun.
Aw,
Yeah.
that's
Stay
so-
warm.
That's
Yeah,
so cool.
yeah.
Yeah, stay warm. So how long are you gonna be gone?
Just a week. Yeah.
Oh,
So
okay.
we get back next
Spring break, yeah.
Friday. So I'll
Yeah,
have
spring break.
the weekend to recuperate and
Okay, well, we'll try to answer as much as we can. If
Yeah.
we need your help, we'll ping you or,
Yeah.
just to
Mhm.
say, hey, and then hopefully we can get that done before you leave, or at least if we have, yeah.
Yeah.
That, so you can have a great vacation.
Yeah.
Thank you. Yeah.
Yeah, thank you.
That was so fun. Thank you very much.
Okay,
Thank
thanks.
Okay.
Thank you, Terry and Harmony.
Thanks, Harmony.
too.
Thanks,
Yeah,
Terry.
thanks,
for all the
Terry and
support
Harmony.
on this.
Okay.
Take care.
Okay.
Have a great trip,
Bye.
Kevin.
Bye. Have a
Okay.
great
Bye.
trip, Kevin.
Bye.
Nice job, Janelle.
Thank you, Harmony. Great.
No problem.
Awesome.
So with the questions, I'm removing anything that you guys already answered as well.
Okay, well, so I think you should put, can you put questions that and just put already answered so we can see like all the questions and what we answered, just so that maybe we might want to have a written or maybe do a follow-up if anything.
Sure.
And then can you also put the person who asked the question?
Yeah. Mhm.
Yeah, that'll be good. Like, like over here, Gerald Yamamoto, he is an attorney.
Yeah, I figured.
Yeah.
There's some attorneys in here as well.
Yeah. Yeah. So,
Curtis Yan.
oh, Ewan, Curtis Ewan.
Mhm.
That's interesting. He's super busy. Why is he on these? Like, it's like he's like our #1 referrer. Oh, except real estate or closely held entities. Yeah.
Yeah.
Well,
So,
okay, awesome. Thank
Yep.
you.
no problem. Okay,
Thank
have a good
you.
rest of the day.
Ugh, thank you. Bye-bye.
Bye.